The Supreme Court allowed the appeals in the matter of the Auroville Foundation versus Natasha story. Court stated that some disgruntled and discontented residents kept on filing petitions one after the other, dragging the appellant foundation into unnecessary litigations. The writ petition filed by the respondent before the High Court was one of such ill motivated petitions filed by her to abuse the process of law, to hamper the development of Auroville, and to cause obstruction in the smooth functioning of the governing board of the foundation. Hence, the appeal was allowed with a cost of rupees 50,000 to be deposited by the respondent before the Supreme Court Legal Services Committee within 2 weeks. In 1965, the mother, Mira Alfasa, a French lady, a spiritual collaborator of Sri Aurobindo, a spiritual reformer, philosopher, and educationist, envisioned to launch the project of Auroville with an aim to establish an international universal township where men and women of all countries are able to live in peace and harmony above all creeds, all politics, and all nationalities, and to realize human unity. The project of Auroville was formally inaugurated by the mother in 28 February 1968. The charter of Auroville given by the mother was the following: Auroville belongs to nobody in particular. Auroville belongs to humanity as a whole. But to live in Auroville, one must be a willing servitor of the divine consciousness. Auroville will be the place of an unending education, of constant progress, and a youth that never ages. Auroville wants to be the bridge between the past and the future. Taking advantage of all discoveries from without and from within, Auroville will boldly spring towards future realizations. Auroville will be a site of material and spiritual researches for a living embodiment of an actual human unity. The original master plan of the Auroville was conceptualized in galaxy shape and was planned to eventually accommodate 50,000 residents, a number of which the mother considered sufficient to allow the experiment in human unity to take on a meaningful and significant dimension. The Project Auroville was legally started as the project of a charitable organization, the Sri Aurobindo Society in Pondicherry, which was created to diffuse Sri Aurobindo's thoughts. The development of Auroville in initial few years showed good progress, and it further developed at a rapid pace. Number of Indians and foreigners settled down in Auroville and devoted themselves to various activities, showing a remarkable harmony amongst the members of Auroville, which gave a promise to the government of India of an early fulfillment of the ideals for which Auroville was established. It was also encouraged by UNESCO and other international organizations of the world. However, after the mother passed away in 1973, the situation changed. A number of complaints came to be received by Government of India with regard to mismanagement of the working of Sri Aurobindo Society. Following requests by majority of Auroville residents, the Government of India issued a presidential ordinance called the Auroville Emergency Provisions Ordinance 1980, later replaced by the Auroville Emergency Provisions Act 1980. Finally, the Government of India created a unique status for Auroville by passing the AF Act. Section 16 of the Act, said Supreme Court, empowers the governing board to appoint such committees as may be necessary for efficient discharge of its duties and performance of its functions under the Act. Even as per Rule 5 of said rules, the governing board is empowered to constitute the committees under subsection 1 of Section 16. As per Rule 5.2, it is governing board alone which has to determine the composition and functions of every committee constituted by it. Neither the said AF Act nor the said rules contemplate or confer any right upon the Residents' Assembly, much less upon an individual resident of Auroville, to be part of any committee or council constituted by governing board for efficient discharge of its duties and functions under the Act. From the conjoined reading of the provisions of the AF Act and the said rules, there remains no shadow of doubt that the governing board is vested with all the powers and is empowered to discharge all the functions as may be exercised or discharged by the foundation, and that general superintendence, direction, and management of the affairs of the foundation vests in the governing board alone. Though it is true that Section 19(1)(c) required the Residents' Assembly to assist the governing board to formulate master plan of Auroville, however, the said stage was already over when the master plan was prepared by governing board in consultation with Residents' Assembly as contemplated in Section 17(e) and was then approved by central government, Ministry of Human Resource Development, way back in 2001. After the publication of said master plan, the governing board had issued standing orders from time to time for implementation of said approved master plan and for development of Auroville as planned. Court said that it appears that some disgruntled residents of Auroville, instead of cooperating with the governing board of the foundation in implementation of said legally approved master plan and in carrying out the development work of Auroville as per said master plan envisioned by the mother, started causing obstructions by filing the petitions in High Court of Judicature at Madras, one after the other, dragging the appellant foundation into unnecessary litigations. Court said there is no legal or statutory right conferred upon the Residents' Assembly or upon an individual resident to be part of any committee or council constituted by governing board in exercise of powers conferred under section 11(3), section 16(1) and 17(e) of the said act, read with rules 5(1) and 5(2) of said rules. The functions of Residents' Assembly are confined only to advise the governing board in respect of activities relating to residents of Auroville and to make recommendations as specified in section 19 of act. Court said, we are of the opinion that High Court has thoroughly misdirected itself in misinterpreting the provisions of AF Act and in setting aside the impugned notification contained in the standing order dated 1 June 2022. The impugned order, being highly erroneous, deserves to be set aside and is hereby set aside.